it, which is provide purpose, having us do, we've also marked out judicial confession and changed it to no contest.
Oh, you can change all of that to no contest, but you can't change what you're stipulating to, because otherwise she's not even stipulating to the fact that she owed $1,000 to the junior league.
Well, Judge, she doesn't have to stipulate to it. No, she's pleading no contest. And so that is the plea that's provided in order for people who disagree with what's being said to be able to move forward with a plea. I've never had a problem with that before. I've done it in this court.
No, I tell you what has been done. There has been, with regards to the indictment that's a part of it, where you say, I am not contesting anything, and you take out the judicial confession, but the evidence is the evidence that is presented. And then the court makes a ruling on whether or not that evidence is sufficient. But if you're saying we're not stipulating to the evidence that is being presented to the court, then she's not even stipulating to the fact that she's alleged to have committed a theft from the junior league.
I think we've got a clean copy of the paperwork, Judge, that we can.
All right, Judge, if I may, we can't stipulate to the amount.
In 2024 CR 011624, State versus Jan Hawkins, AKA Jan Madura. Can I have parties announce?
Chandler Bowen for the state of Texas.
Linda Corley for Ms. Madura.
And are you Ms. Madura?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Off the record for a moment. So they have her AKA is Jan Madura, but that's her name, correct?
The case was originally submitted as Jan Hawkins.
Okay, but shouldn't Jan Hawkins be the AKA and not Jan Madura?
I think as long as they're both there, it's okay, is my understanding.
Okay, because all of the other paperwork doesn't have an AKA listed.
We don't have any objection to that, Judge.
All right, we're back on the record. Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
And are you Jan Madura?
Yes, Your Honor.
All right. And you're not Jan Hawkins, correct?
No, Your Honor, I'm Jan Madura.
Thank you. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we are waiving count 1. We're proceeding on a lesser included of count 2
And what are you proceeding on?
on a Class A theft.
No objections, Your Honor.
All right. Did you review the court admonishments with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it in electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand the state is proceeding on the lesser included offense of theft, $750 up to $2,500 as a Class A misdemeanor? Range of punishment is anywhere, it's up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you are giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Miss Madura, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Did you understand by entering this plea, if you're not a U.S. citizen, you will be deported, denied naturalization, and the right to re-enter the United States?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense under count 2 of theft, $750 to $2,500. They're waiving count one. They are recommending deferred adjudication. They say that you've paid $1,077.01 to the Junior League of San Antonio. And I'm assuming there are no other outstanding restitutions.
There's one that we've got on there below the line, Your Honor. There was an insurance claim that was made by the complainant by Berkshire Hathaway. It's reflected toward the bottom.
All right. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Your Honor, we understand that we can address the court on the any restitution to third parties, but yes, other than that, it is our agreement.
State, is that the plea?
That's the plea, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes,
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. They're recommending restitution to Berkshire Hathaway in the amount of $9,799.42 and $227.71 to Visa. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes,
Then to the offense, the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
no contest.
State any evidence.
We'll offer Exhibit 1 with all attachments.
No objections, Your Honor.
Right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, that means that the state will be presenting witnesses in the form of witnesses' statements and police reports, but there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations.
Your Honor, if I may, we did make an amendment to the stipulations in concert for agreement with the ADA. We have marked out we're not saying that all the stipulations are true and correct. We have a controversy on the amount, the final amount. So
I think the issue, Judge, is that if you're intending to impose the restitution to Berkshire Hathaway and Visa, they're going to ask for a restitution hearing. Is the main issue here.
Well, I am going to ask to a restitution hearing.
Okay.
And the fact, these stipulations, you can't just cross out that you're not stipulating that the evidence is true and correct because you haven't stipulated which party you're saying is not correct. When you cross out the stipulations, then you're saying we're not stipulating to any of it. So you all will have to correct your paperwork.
Judge, if I may,
Mhm.
we've done this before. We are
Not
pleading
with
no.
me.
Actually, I have on one prior plea on a case that was a family violence case, Judge, in this court. But we are pleading no contest, which means we don't necessarily agree, but we're not fighting about it, which is provide purpose having us do. We've also marked out judicial confession and changed it to no contest.
Oh, you can change all of that to no contest, but you can't change what you're stipulating to, because otherwise she's not even stipulating to the fact that she owed $1,000 to the Junior League.
Well, Judge, she doesn't have to stipulate to it. No, she's pleading no contest. And so that is the plea that's provided in order for people who disagree with what's being said to be able to move forward with a plea. I've never had a problem with that before. I've done it in this court.
No, I tell you what has been done. There has been, with regards to the indictment that's a part of it, where you say, I am not contesting anything, and you take out the judicial confession, but the evidence is the evidence that is presented. And then the court makes a ruling on whether or not that evidence is sufficient. But if you're saying we're not stipulating to the evidence that is being presented to the court, then she's not even stipulating to the fact that she's alleged to have committed a theft from the Junior League.
I think we've got a clean copy of the paperwork, Judge, that we can.
All right.
Judge,
swap out.
if I may, we can't stipulate to the amount. So we would have at the very
That's why
least.
you have it. Nobody ever stipulates to an amount. That's why you all have contested hearings and I make a decision on whether or not they owe it or not.
And Judge, and I know we're getting in sort of ahead of ourselves, but I'm asking for the court to not order restitution to the third parties. I don't think that that's appropriate.
Well,
They
that's
have-
where you present evidence and I make a decision, or you present some kind of law and I make a decision on whether or not that amount that is below the line, because it's not a part of your agreement, then I make a decision on whether or not that amount should be paid or any amount should be paid to Visa or Berkshire.
And Your Honor, it's what I'm requesting the court to do is to not order that, so that can be handled in a civil court. They are set up for that. That's the way the normal course goes on these things. And it's going to be, we would need a forensic accountant to go through this. It's going to be a very long and arduous restitution.
I understand what everybody is saying. I want to let everybody know I'm internalizing what's being said. What I am telling the parties is this: if she's not stipulating to the evidence that's been presented by the state, that means she's not stipulating that she even committed a theft with the junior league. I don't know why she paid the amount to the junior league, because she's not stipulating to that. Things that are below the line, that means that it's contested. That means that I'll hear evidence. I'll make a decision on whether or not restitution should be paid to Berkshire or Visa. That's something that I will hear. The only thing you're allowed to do, I don't contest, is when they have in the plea paperwork where it has the indictment on or about whatever, that's like on or about whatever I judicially admit. You can scratch that out and you put, I'm not contesting anything. But for the stipulated evidence, the evidence is what's being presented. Otherwise, if you're not stipulating to any of the evidence, then there's no plea.
Judge, we're willing to stipulate to everything except the final
Then you all
amount.
need to change your paper.
And Your Honor, I know, to press a point on this, it's my understanding, my belief that the law allows us to not stipulate to true and correct. The judge has the evidence and the judge can look at that and decide that they find those documents credible and find that they are true, and or
I can't do any of that if y'all are not stipulating to anything, then everything is a challenge. So this is what I will tell y'all to make it simple. I'm not accepting this plea.
Okay, we'll redo the paperwork. Would you
All right.
accept if we just simply put on that we do
Oh,
not
y'all
stipulate to the final amount?
Y'all do the paperwork. And if y'all want to put in there that the final amount from Berkshire and Visa is contested, which to me, you've already said that. That's why it's below the line. If y'all want to do that, fine. But everything else, no.
And you understand that all the money was for the junior league, but they just filed an insurance claim and a Visa claim.
Here's the thing. I haven't read any of the evidence, so I don't know what y'all are presenting because y'all haven't stipulated to anything. I don't know why there's an objection to outside the agreement. Everything that is outside your agreement is contested, and I'll hear evidence. This argument that you all are making on she doesn't owe to Berkshire, she doesn't owe to Visa, we haven't even got to that point yet because nobody stipulated to anything. And when things are below that line, that means that it's contested. That means I'll hear arguments. I'll hear whatever kind of law somebody wants to present me on whether or not you should be paying that under this cause number.
And Judge, the reason I am making this issue is because it says in the documents that higher amount. So we don't want to stipulate to that. So we'll change the document to say that and we'll reapproach.
Oh, y'all need to reprint that entire document out because that's been sworn to. She's been sworn to that specific document by the clerk. And if people start making changes to that document, it's no longer a sworn document.
We can do that, Judge.
Okay.
Thank you.
So, yes. 2025 CR 015632, State versus Christopher Polito. Could I have parties announced?
Derek comes from Mr. Polito.
And are you Mr. Polito? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Polito, did you review the application for community supervision with your attorney? Did you understand it? And did you sign it? Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented? Yes, Your Honor. Ms. Polito, did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, penalty group 1 to 4 grams. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. All right. Counsel, has your client been able to provide you with any defenses?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against
In
him?
my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Polito, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 6 years in the prison. There's a $1,200 fine and the state is opposed to your application. Did you understand that to be the plea?
Yes.
Defense?
It is, Your Honor.
State?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motion?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Yes, Your Honor, state offer states if we can in all time.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find that there is sufficient evidence to find you guilty, and the court will find you guilty. What is his criminal history?
State theft as well as conviction for burglary of ability and possession E1 two felonies were referred to.
Okay. All right. Are you waiving PSI?
We can, the state's opposed, but we can.
Well, no, my question is, are you waiving PSI?
You want the judge to make the decision, then you want to wait 30 days.
I'm gonna make a decision.
We'd wait the PSI, Judge.
All right. And state you're opposed, and why are you opposed?
From this judge, we are opposed. Mr. Polito was placed on probation in 2023 as well as that drug conviction in 2023, and then picked up this new case. So he's already done a trip to TC on that 1 to 4 grams of heroin.
All right, thank you. So why were you revoked on your last probation? What did you not do?
Report.
Okay. And how often have you been using drugs?
I was 26.
And what have you been using?
Marijuana at first, and then it went to cocaine. Then cocaine went to meth. And then I started drinking. And then I just stayed on meth.
And do you have any children? What are their ages?
15. She lives in Austin. I have 2 live right now with my parents, and a 7 and 8-year-old. And then I have a 3-year-old.
All right. So here's the thing. I'm going to give you a choice. There are no other choices. Don't ask me for a third option. Either choice that you make is going to result in you being in custody. First choice, I'll find you guilty, as I already have done, sentence you to prison for 5 years. Next choice, I'll grant your application, and I will sentence you to 6 years in the prison, suspended and probated for 8 years, but you're going to remain in custody. You're going to be referred to felony drug court. If they do not accept you, you're going to be going into inpatient treatment somewhere. So those are your only options. And the only reason why I'm giving you these options is because sometimes it's not good to kick the can down the road. You have these children who are depending on you for support. And one or two things going to end up happening if you don't get treatment. Either you're going to end up in prison for the rest of your life, or either somebody's going to end up identifying your body. So which do you prefer? 5 years in the prison, or either you remain in custody until you're accepted in felony drug court, or either into an inpatient drug treatment? All right. Thank you, counsel. All right. This is what the court will do. The court will sentence you to 6 years in the prison, suspended and probated for 8 years. The following is to take place in custody: a referral to felony drug court, TAP evaluation. If not accepted into felony drug court, then inpatient treatment. And that inpatient treatment, probation, if TAP evaluation approves, will be SafeP. There's to be regular reporting by Zoom or in person, regular random UAs, field visits 1 time per month until further notice upon release from custody. There's going to be 200 hours of community service restitution. I'm going to order parenting classes. Once parenting classes are complete, 50 hours will be deducted. The remaining community service hours, you can either do 150 in the heat, which it's going to get hot pretty soon, or there's going to be one sober support. For every sober support meeting completed, that's your AANA meetings, 1 hour of community service restitution will be deducted. There's to be no unsupervised contact with minors. That may change once you prove to the court that you can be clean and sober. There is to be a $1,200 fine. That will be probated. Proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. Probation, is there anything else?
No, Judge.
Is there anything else you need from the court in order to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. You have children who are depending on you 100%. If you continue the way you're going, some other man is going to end up raising your children, because either you're going to end up spending the majority of your time at the Bexar County Jail or in prison, or either somebody's going to have to identify your body, because the last time you use may be the last time you use. In this court, communication is key to be successful. Talk to your probation officer. If you ever feel like, once you've completed the inpatient program you're going to use, call your sponsor, call probation. If you call probation and you tell them that you're thinking about using, you know what they're going to do? They're going to get you some help. If you come in here and talk to me and say, Judge, I'm struggling, I think I'm going to use, guess what I'm going to do? I'm going to get you some help. But if you don't report, we're going to have a problem. You understand? Yes. All right, good luck to you. Calling 2024 CR 4236, State of Texas versus Paul Anthony Luna. Can I have parties announced for the record for the state? Defense.
Michael DeLeon for Mr. Luna.
Are you Mr. Luna?
Yes, ma'am.
Counsel, have you received all the discovery?
I have, Your Honor.
Did you review with your client?
I have.
Are there any applications?
No applications, Your Honor.
Mr. Luna, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, well, we're waiving one of the enhancement paragraphs and proceeding on a repeater, aggravated robbery.
All right, is there a specific enhancement paragraph you're waiving?
Yeah, we're waiving the last one.
All right, so the state is proceeding on a repeater count with paragraph 1.
That's correct. We have no objection.
Okay. All right, did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of aggravated robbery Normally, that's a first-degree felony. If the state proves up the repeater paragraph allegation, then your range of punishment will be anywhere from 15 to 99 years or life in prison. Did you understand?
Yes, ma'am.
And that is for count 1 and count 2. Did you understand?
Yes, ma'am.
Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea? If for
Yeah.
any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do believe he's competent.
And was sane at the time of the offense?
Yes.
Mr. Luna, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 1 and 2. You're to agree that you've been previously convicted for enhancement purposes. Punishment is to be assessed at 20 years in the prison. There's an affirmative finding of deadly weapon. There are no applications. The state is taking in consideration 2024 CR 4237. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea?
That's correct, Your Honor.
State is at the plea.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No motions, Your Honor.
Outside the agreement, the state is requesting that you have no contact with Xavier Valero, Sergio Martinez, and Margarita Segovia. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to count 1 in an indictment, how do you plead? Guilty, not guilty, or no contest?
Guilty.
And count 2, how do you plead? Guilty, not guilty, or no contest?
Guilty.
To the repeater paragraph, how do you plead? True or not true?
True.
State any evidence.
Yes, Your Honor.
We've reviewed that, Your Honor. We have no objection.
Did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it at all the appropriate places?
Yes, ma'am.
Again, did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting witnesses in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty of count 1 and count 2. The court will find you guilty of count 1 and count 2. The court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Are you proceeding with sentencing?
We are, Your Honor. I think Mr. Luna wanted to say a few words to the court.
All right, you want to raise your right hand?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record.
Paul Luna,
All right, what would you like to say, sir?
is it okay if I read this to the court?
Have,
Haven't seen it, Judge.
I mean, it's not, it's just, it's not asking for no time off, not for my freedom,
Sure.
nothing like that.
I don't have any objection. No objection.
Your Honor, my name is Paul Anthony Luna Jr. I'm 31 years old, and I wanted to take this time to tell you a little bit about myself because no one seems to hear me out on the situation I'm in. and why the crime was committed. I'm a heroin addict and I've been doing heroin since I was 16 years old, on and off because I was doing good working at times, but my demons would take the best of me. So I will fall back into my addiction. The only thing that keeps saving my life is getting locked up, which I hate to say, but it's true. And I thank God for that. I would inject black tar heroin, which I'm not proud of because I've lost a lot behind my addiction. I was strung out dope sick when the crime occurred. If I had the chance, I would ask my victims for forgiveness for putting their lives in danger. I regret doing what I did because I know now I'm wasting my life over a fix. Your Honor, I'm not a bad person. Anybody that knows me can tell you I'm a good person when I'm not on heroin. But every time I get strung out, I make mistakes that I gotta live with, and I'm not proud of it. And the people that don't know me want to paint a picture of me like I'm just an evil person because what they see on paper or go off of what other people say that don't know me. So I'm pleading with you, not for my freedom, but for help with my addiction. This will be the first time I've asked the court for help because I see you're a judge that helps people that want the help. I don't want to keep going back to my addiction because of my weak mindset, and I'm not afraid to admit that. So I'm asking for your help to fix the problem that I have with, which is my drug addiction, because this is a cycle that needs to be broken. So thank you, Your Honor, for hearing me out of the problem in my life. All I gotta say, Your Honor.
All right, thank you. All right, I'm going to sentence you. I am going to ask that you be placed in the therapeutic community.
Thank
They
you.
can address your drug issues. I have no jurisdiction to place you in the therapeutic community, but if you don't ask for it, they're definitely not going to give it to you. You understand?
Yes, ma'am.
All right, the court is going to follow your agreement, sentence you to 20 years in counts 1 and count 2, taking consideration 2024 CR 4237. Counts 1 and counts 2 will run concurrently. Give you credit for any time served. There's to be no contact with Xavier Valero, Sergio Martinez, Margarita Segovia, and there's an affirmative finding of deadly weapon. Is there anything else with regards to sentencing? right.
Nothing from the defense.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it
Yes, ma'am.
and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we're gonna go off the record for a moment. Here's the thing. You're not gonna be in prison for the rest of your life. It's 20 years.
I understand that.
All right. Once you are released, you need to quickly go to a rehab center to get inpatient treatment. If you end up receiving parole from the prison, they will give you help. They have programs you will need to ask for. If you're released and you can't find a place for your treatment for sobriety to maintain it, if I'm still here, as they say, if God willing and the creek don't rise, you can come back here and I will personally pick up the phone and call someone to make sure you're in inpatient treatment. All right?
Thank you.
All right, good luck to you.
All right, you too, ma'am.
2024 CR 2594, State of Texas versus Mark Anthony Perez. Could I have parties announced for the record for the state
Zach Dunn for the state.
defense?
Raymond Martinez.
And are you Mr. Perez?
Yes, ma'am.
Counsel, have you received all of the discovery and did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Did you review the document entitled Application for Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with injury to the elderly, bodily injury? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial? a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent.
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Perez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes. Yes, Your Honor.
According to the plea, punishment is to be assessed at 2 years in the prison. State recommends community supervision. They're taking in consideration County Court Cause number 731618. There's an affirmative finding of family violence, TAP evaluation, follow those recommendations, mental health evaluation, and follow those recommendations, and no contact with Juan Perez. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes. Yeah, yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yeah, yes, Your Honor. I understood that.
Did you understand that to be the entirety of your agreement?
Yes. Yes, Your Honor. Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the paragraph entitled Waiver of Appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did
Yes,
you
Your Honor.
understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. Did you understand those are recommendations from the state and the court does not have to follow that recommendation?
Of course, Your Honor. I understand.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor. State law for states 1 and attachments.
No
Any
objection,
objection?
Your Honor.
Have you spoken with the complainant?
We had spoken with the complainant under yes.
All right, you may continue to confer.
Thank you, Judge.
You're welcome. Mr. Perez, did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor. Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor. Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are we proceeding with sentencing?
Yes, we'd like to, Judge.
Anything you wish to say on behalf of your client?
Judge, what I can tell you is that Mr. Bettis is under a protective order with his father, that he's been abiding by it. Although there was one minor slip up, his brother actually lived next door to his father, so he goes to his brother's house, it was too close to his father's. But he's very, very much aware of what he can and cannot do,
Yes, ma'am.
and I think he will comply with the conditions of probation.
All right. So, do you have any prior mental health issues?
May I say it?
Sure.
Before I was incarcerated, my parents, I understand, my mom, mean, I was getting, I was getting, in the past, I was getting help at the Center for Healthcare Services for my, like, not that, I was on Risperdal, or Risperidone, just for, for anxiety, but I didn't get to do that before, so that's that.
He was having difficult, he's talking about the day of the incident, Judge, he was having a difficult time.
All right. So, other than anxiety, have you ever been diagnosed with anything else?
No.
All right. When's the first time you saw a doctor for mental health issues?
for 2024, I was saying it was in 2021.
So how old were you then?
I was 32,
All right.
36.
Drug use.
I've been clean for the last 2 years, please.
Well, whatever. I understand. I'm trying to figure out history here. So you've been clean for the past 2 years. What have you been clean from?
Alcohol.
And what else?
drugs.
What type of drugs?
I was just smoking marijuana.
All right, so here's the thing. I'm trying to set conditions for you. I don't do cookie cutter conditions because I want people to be successful. But if you're not honest with me about what you use, what's going to end up happening if you'll be sent off in the world unprepared. And then when you come back to court, which you probably will on a motion to revoke, you're going to want to tell me everything about your life at that point. So it's best that you tell me now. So alcohol, marijuana, what else?
That's it.
Okay. All right. Anything else?
No.
All right. I'm going with the alcohol and marijuana. And so nothing else had better come up in your system.
Yes, ma'am.
All right. The court is finding you guilty. Do you have any children?
I have one son. He's 12.
All right. And who does he live with?
He lives with his mother.
When's the last time you saw him?
Um, 3 months ago.
All right.
3 months.
3 months ago. All right. As previously stated, court is finding you guilty. The court is going to sentence you to 2 years in the prison, suspended and probated for 3 years. Take in consideration 731618. There's an affirmative finding of family violence.
That's right.
There should be a TAP evaluation. How long is the MIC in custody?
That's probably about a month.
All right. There should be a TAP evaluation in custody and out of custody.
To go through the whole process.
All right. So we'll do a referral to Center for Healthcare Services. If there's some issues with that, Ms. Abrams, then we may have to take him into custody and do the mental health evaluation at that point. So when they give you the referral for Center for Healthcare Services, you had better go.
Yes, ma'am.
Otherwise, what's going to end up happening is you may end up waiting for 30 or 45 days. You understand?
Yeah, Mr. Kate, may I say something?
Sure.
That's the first thing I'm gonna do as soon as I'm released.
All right. There's to be regular reporting
Yes, ma'am.
by Zoom or in person.
Sure.
The UA hotline until further notice. There's to be no contact with Juan Perez.
Yes.
There's to be no unsupervised contact with minors. 200 hours of community service restitution. I'm going to order parenting classes. Once he completes those, the community service hours will be deemed satisfied. There's to be 90 sober meetings in 90 days. Field visits 1 time per month. For 3 months after he has received documentation from Center for Healthcare Services. So once he gets documentation for Center Healthcare Services, then 3 months for field visits, then as probation deems necessary. There's to be an anger management course. And MRT. When's the last time you had employment?
So, 2023.
So how you been supporting yourself?
I have jobs that are on the table.
All right, so we're not gonna do under the table in here, all right? So
I have a job waiting for me as soon as I get out here.
There's-
I'm gonna work at the Little Red Barn Steakhouse for the 5th time as a chef there.
all right, so proof of employment within 30 days.
Yes, ma'am.
There's to be no employment as a home health care provider or with minors.
Yes, ma'am.
Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
No, ma'am, thank you for understanding and bringing me just like that's.
Okay,
Oh,
court
I'm sorry.
reporter is not picking up what you're saying because you're mumbling.
Thank you for everything. Thank you, Your Honor.
All right, you're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor. Completely understand.
All right, we can go off the record. Here's the thing, to be successful in this court, when you're on probation, communication is key.
Yes,
If
ma'am.
there's an issue, let probation know about it. If you feel as though they're not addressing it, you can always come back to the court.
Thank you very much.
You're welcome. Good luck to you.
A fatal hit-and-run driver begs for probation. He swears he thought it was a dog, but his girlfriend and friends say he admitted hitting someone, then rolled over and went back to sleep. The judge drops the maximum.
2024 CR 007421, State versus Johnny Ruiz Jr. Can I have parties announced for the record? State. Defense.
Ray Lopez for the defense.
And are you Mr. Ruiz?
Yes, sir.
All right, you entered a plea on January 28th of no contest to the offense of collision involving death. According to your plea bargain agreement, punishment is to be assessed at a cap of 10 years in the prison. There's a $2,000 fine. The state is opposed to your applications, and there's to be restitution to the next of kin of the deceased. Have both parties had a chance to review the PSI report, state? Yes. Defense?
Yes, Your Honor.
Any objections to the PSI report, state? Defense?
No, Your Honor.
Any witnesses, state? Defense, any witnesses?
To Your Honor, my client and his employer, who's going to be very brief.
Oh, well, it can take as long as it takes, but,
Two witnesses. Your
all
Honor.
right, who would you like to call, counsel?
I'll call start with Mr. Reese.
All right, Mr. Ruiz, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
It's Johnny Reese Jr.
All right, defense, you may proceed.
Thank you, Your Honor. So you're here today asking the court for probation. Is that correct?
Yes.
Can you tell the court in your own words kind of what happened that day of the incident?
I had just gotten off of work that day. Went to a friend of mine's. We were supposed to catch up on a video game. That's what we did most of the night. From there, we got something to eat before we got any later. Anything closed down. We ended up getting some Fred's fish that day. No, I believe they took a little bit longer. I fell asleep on a nap waiting for them. From by the time they got back, I noticed it was already late. Got some ice, you know what they brought. From there, I took off home for where we were staying at, where I was staying at. And during that moment, something happened and ended up. Sorry. Noticed I had hit something. Wasn't too sure what it was. The fact that it was dark that in that area. Drove a little bit further down, stopped. Before I saw a light, I believe there was a hotel there. Figured maybe I'd stop there just in case he did see anything or anything happen. I was able to offer help, off the horn, something. So my window down, I didn't see anything. Didn't see nothing. I didn't hear nobody. Assuming that, it may have struck an animal or something. So I left. Got to where I was staying at and you know, I saw there was damage on the windshield, of course. I didn't see anything, you know, that indicated that there's a person, a dog, an animal. I'm pretty sure if I would have hit an animal or something, I would have saw blood or whatever the case is. But didn't see anything that I figured. I was like, maybe somebody threw something in my car or something. I mean, if there was nothing wrong, you know. That's when I started thinking negative, like, you know, and I would have stopped there, or something would happen to me. Somebody did throw something in my car. At that point, I figured this, you know, that I would have been okay. I mean, I didn't see nobody. Next morning, I knocked on the door. It was a detective and told me that there had been an accident. And I might have been involved in something, you know, an accident that happened down the street. You know, I just couldn't believe it. It just said it was an accident under a person. I asked, was everything okay? Were they okay? The detective assured me that the person was fine. I picked him up. He was in the hospital. That he was going to be fine. Except they took me in that day as well. So just, I guess, to the interrogation room or wherever they take me. They just asked me what happened that night. Same thing that I'm saying now. From that point, I mean, like I said, the detective assured me that he was going to be fine. He was okay. They just needed to find out what happened. Also told me that, you know, he was in the wrong because he was in the street. You know, as far as what he told me, well, I didn't see who it was or what it was. He told me that, you know, it was a person. It was, it just upset me. I just wouldn't think in my right mind it would have been somebody there walking in the middle, you know, dark alley.
So when did you come to learn that the person that you hit in the collision ultimately passed away?
It wasn't until a few months later I had learned that he passed away 2 weeks after he had been struck.
And how do you feel about it? Can you tell us what your mind was going through when you learned that information?
Horrible. I gotta live with
I'm sorry, what?
something that I have to live with. It's a terrible feeling.
Do you still think about it to this day?
Think about it every day. Every day. Can't go to sleep. There's times when I stay up till 4, 5 in the morning. I gotta go to work the next day. I gotta work through it. It bothers me every day.
Why do you feel that you're a good candidate for probation?
I have a family. I mean, I have my kids. I have an obligation to support my kids. I love them a lot. Back to being away from them, not being able to help them, provide food. You know, I've tried to, with the state as well, asked them, is there any way they can pay any type of restitution? You know, as well, you know, kind of take responsibility for what's going on. And for the court to grant me probation, I can continue to do my best to, to work.
Now, have you been employed? How long have you been employed for?
For the past year, I think we started in February. So it's a little over a year already.
And where are you employed at?
It's a company, it's a landscaping company.
And do you know if you'll be able to continue your employment after, if you get put on probation?
Yes. Sure I will.
And aside from your children, do you have any other family members that you're helping to they rely on you?
Well, I mean, at the time, right now, it's, my kids, my mother's sick, other than that, she's disabled, so. I mean, I'd really like to get to be more involved with her as well.
And have you had any criminal, have you ever been arrested in the past 20 years?
No.
And you
I've
haven't,
never been arrested.
and how old are you?
38 years old.
So do you have a few incidences when you were a minor?
Well, I believe so. I think it was, I think in middle school. No, there was one incident that I went to juvie for a day or so. I can't remember how long it was.
But since you've been an adult, you have not had any issues with the law until
No, sir.
this incident. Last witness.
Any questions? Yes, Judge. So Mr. Ruiz, at the time of the offense, you were staying at a roadway inn that was located on Enrique Barrera Parkway, is that correct?
Yes.
Okay, and so the accident happened somewhere on Old Highway 90, is that correct?
Yes.
And so those locations are kind of close to each other, right?
Yes.
Okay. Can you kind of give me an idea? You said that you stopped at a hotel. Did you stop at the roadway inn or a different hotel?
Well, I mean, where I was staying, I can't remember what it was called. I think there's several hotels that were there. I stopped at the very first one. Like I said, where I saw that there was some kind of light. It was dark in that area.
Okay, so you stopped at a different hotel, not the hotel that you were staying at.
No. Stopped at a different hotel. Yes.
Okay, thank you. And so regarding your vehicle is a relatively small vehicle, correct?
Yes.
It was a smart passion, like a smart car, is that correct? Okay, and so it had a good amount of damage to it, wouldn't you agree with me? So it had the broken windshield concentrated on the passenger side, right?
Yeah.
And then it also had passenger side body damage, correct? And then the broken or the headlight on the passenger side was also broken. And then the passenger side mirror was also missing. Is that correct?
Yeah, I believe so.
Okay. And so in the PSI and in your testimony today, you said that there's a lot of dogs in the area. Is that correct? Okay. And so you said possibly you thought that you hit a dog.
Yes.
The evidence that I've seen in the case suggests to me that when the complainant was hit, the body flew up onto the windshield, causing that impact. Is that fair to say?
Yes.
Okay. And so if you were to hit a dog, obviously a dog is not as tall as a human, right?
Yes.
And so if you were to hit a dog, you would have felt the impact of rolling over the dog, right?
Possible, but for that type of vehicle, it's so low to the ground and tiny, anything hits that windshield goes up.
Okay.
Because it's such an incline, that smart car.
So you think it's possible if you would have hit a dog that the dog also would have flew up onto the,
As well.
okay. And so then I have some other questions. So you said the first time that you learned that you were involved in a collision involving a person was when the detective came to the hotel. Is that correct?
Yeah.
And before the detective took you downtown to take a statement from you, he kind of spoke to you at your hotel room, right?
Yeah.
And so when he was speaking to you at that point, you told him that you believe that the damage to your vehicle was caused by a tree that had fell on the vehicle, right? Okay. And so you weren't forthcoming with him at that time, right? Okay. And regarding, who is Cecilia Rodriguez?
That was supposed to be, my wife or my ex-girlfriend
Okay.
at this time.
And is she the mother of one of your children?
Yes.
Okay. And so she has no reason to say anything false against you, right?
She should.
Okay. And she was staying with you at the roadway and at that time, right? All right. And so Cecilia stated that she confronted you. So Cecilia noticed the damage, right, that night?
No, she didn't go out that night. She didn't see nothing that night.
Was it in the morning that
It
she
was in
saw
the
it?
morning when-
Okay. And so when she sees the damage to the vehicle, she confronts you about it and you tell her you don't know what happened, right?
Yeah.
Okay. And then she stated that based on what she saw, she believed that you hit something, right?
I don't know exactly what she said. No.
Okay. So if that evidence is stipulated too, so I'll just move on. But Cecilia also stated that she believed that you looked inebriated on that day when you returned to the hotel room that night. Were you under the influence of alcohol or drugs?
No.
Why would Cecilia say that?
I'm not too sure, to be honest with you, because she wasn't even present of anything. You know, when I walked in trying to figure out what was going on. I undressed myself and got into, you know, my sleep clothes.
Mm-hmm.
I didn't really even talk to her that much. I mean, when I got there, she was already asleep. When I, you know, you got a key card to walk in.
Mm-hmm.
So she was asleep. Like I don't see why she would say.
Okay, and then who's Edward Vargas?
That's a friend of mine that was, well, at the time was a friend. He was in the vehicle as well.
Okay, and so does he have any reason to say anything false against you? Okay, so my question is, why would Edward Vargas and Cecilia Rodriguez say that you told both of them that you saw something on the news regarding a hit and run?
That was afterwards.
That was in the morning, right?
Yeah, that was in the morning.
Before the police showed up at your hotel?
Like, yeah.
Okay, so you had some knowledge of what was going on, correct?
Yes.
All right, and just going back to Cecilia, she stated that you stated to her that you hit someone, and when you told her that, she rolled back over and went into bed.
I didn't talk to her as much as, you know, she was already in bed when I got there.
Okay, so all those other facts are correct. She was at the hotel room, she was in bed, she was asleep, she woke up briefly, but just not what you said.
Yes.
It's not.
Understand how something like that would come about.
Okay.
I mean, when I got to the hotel, they were asleep. She was asleep. My son was asleep.
Mm-hmm. Then later on, when you are talking with the detective, you state that you were driving the vehicle on the night of the offense and that you swerved to avoid hitting something on the side of the road and didn't stop, correct?
Yes.
But you were driving that vehicle that night, correct? You were the one that was involved in the collision that caused the death, correct?
Yes.
And you weren't exactly forthcoming in the investigation, right?
And at the time when he asked me these questions, I didn't know where he was going with it. So there might have been a little defense on my end, yes.
Okay. And then I know you said to this court that the court should grant you probation because you have family and kids that you have to provide for. I mean, do you think that's fair? The victim has kids that he can't provide for or be there for. Do you think that is fair?
I was of the understanding that he didn't have any kids.
Well, he does, and they're here today. I have no further questions, Your Honor.
Any further questions?
None of this witness, Your Honor.
All right, you may call your next witness.
I call Mr. Pajato.
Oh, could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, defense, you may proceed.
Sir, how do you know Mr. Reese?
He's been working for me for a little bit over a year.
And how is he employed? In what manner of work?
He's we it's a landscaping irrigation company. He works in one of the crews.
Okay, and how have you known him to be as a person while he's been under your employment for the past year and
It's been 13 months, so since he's been honest, reliable, he goes to probation and he comes back to work the same day, 9:30, the latest, the time.
will he continue, if he is granted probation, will he continue to be employed through your company?
Yes, sir.
And if he is granted probation, are you willing to work with him to have him do whatever classes, community service hours, whatever conditions the court imposes? Are you willing to work with the schedule so that those can be, he can complete those?
Yes, sir.
Pass the witness, Your Honor.
Any questions?
No, Judge.
All right, thank you so much for coming down. All right, Mr. Ruiz. I just have a few questions if there are no
Yes, ma'am.
objections. All right, so in the stipulations, when the officer comes to the hotel, you say that you said that a tree caused the damage to your vehicle?
Yes.
All right, so you're saying you thought that or what?
Well,
Did a tree fall on your vehicle?
No,
So why did you think a tree caused damage to your vehicle?
at that time at night, I felt like when I didn't see anything that the next morning was.
No, I'm just wondering,
I didn't know what he was going with it, Your Honor. I thought maybe I was, at that point getting blamed for something else that I.
so did you know a tree had not fallen on your vehicle or caused damage to your vehicle?
Yes, I did. It didn't.
So you knew that it wasn't a tree? I need yes or no.
Yes.
All right, and then according to the stipulations, there were 2 pedestrians in the roadway. So did you see any of those pedestrians? And then it states that this Rodriguez person, they're stating in the stipulations that you stated you did a hit and run and that you hit somebody and then you rolled over and went back to sleep. So did you ever tell that person you hit someone?
No.
So why would they say that?
No.
Okay.
I mean, I didn't speak to her that night. When I got there, she was angry because I got there late.
Mhm.
But as far as physically talking to her, like I said, she was already in bed. My son was already asleep.
All right, thank you. All right, any further questions?
No question, Your Honor.
No, Judge.
All right, this is what the court is going to do. The court is going to find you guilty. The court is going to sentence you to 10 years in the prison, give you credit for any time served. There's a $2,000 fine. Time and money will run concurrent. There's to be restitution to Francisco Aldaco, and that is to be payable to his next of kin, which is Juanita Aldaco. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. Anytime that somebody does time in prison or Bexar County Jail or in custody is a lot of time, but you still have more of your life in front of you to be a better person. You understand? All right.
Judge, we have victim impact.
All right. So what's going to end up happening is someone's going to speak to you. Just internalize what's being said. Okay.
Judge, we would ask the court to maintain jurisdiction over this, see if we come back in 6 months.
No. All right. Thank you.